Hello, everybody. Good morning from the West Coast. My name is Nancy, and I'm a PM coach. I'm also the host of these live streams that I host every couple of weeks. And today, I'm so happy to welcome Alex to my channel to answer a lot of the most frequently asked questions around employment issues, negotiations, etc. And a little bit background about how this event came to be. In one of my earlier live streams, we talked about negotiation best practices when it comes to compensation. And as a result of that event, we received some questions offline that are better suited for a lawyer to answer. So Gerta, who was my guest from the negotiation event, introduced me to Alex to further serve our community in answering some of these most frequently asked questions. So I'm going to hand it over to Alex. Alex, can you tell us a little bit more about yourself and your background?
Yeah, for sure. Thanks for having me, Nancy. Nice to meet you all, although I guess I haven't met any of you yet. My name's Alex. I'm originally an East Coaster, grew up in New York, New Jersey. Went to school on the East Coast, Duke, and then worked at Google for a few years. Decided I wanted to be a lawyer. I don't know why, but I did. And then I got my JD MBA from Penn Law and Wharton. And then I started working at no one knows law firms, but it's a big law firm called Cooley in Silicon Valley in the Palo Alto office. And from there, I got all my training. And then about a year ago, a buddy and I kind of just realized we didn't really feel like we had much more to learn. And we just really wanted to start our own firm that was a lot more founder friendly. So started a firm with a friend, and I've been doing that since. And yeah, focus on general corporate and anything tied to startups or venture capital and classic Silicon Valley stuff.
Oh, wow, I see. So that is the QR code down here.
Cool.
So when did you start your own law firm?
It was about a year ago. It's like almost exactly a year ago, like in
Oh,
a couple
wow, I
days.
see. And
Yeah,
how did you meet your partner slash friend?
he and I started at Cooley at the same time, and we worked on a lot of the same deals. And I think after too many nights working till like 1 a.m. and pinging each other, we were like, we should just do our own thing. This is crazy.
Oh my gosh.
Yeah. So just shows you
And
can
you're
need a co-founder.
yeah, and you're focusing on founders and venture capital, etc.
Yep, an emerging company. So like anything
Emerging
from like
companies.
Series C company down to like formation, even because we worked on a
Oh,
lot of
wow,
that.
okay. Got it, got
Yeah.
it. So when I put up this event, I also asked people to submit their questions ahead of time. So let's jump into the questions. We put together about 14 questions, which would take us 30 to 40-ish minutes to answer. Well, not really me, but for Alex to answer all of those questions. And for folks who are on the stream, feel free to comment if you have further questions, and we'll see what Alex can do for us. So with that, let's jump right in with question number 1. What are the easiest options for startup founders in terms of setting up a company? S Corp, C Corp, LLC, sole proprietorship? And is there a benefit of one over another?
Yeah. So we'll say disclaimer, this is not legal advice, but happy to do consultations if anyone has follow-up questions. And keep in mind, a lot of these questions probably people do write textbooks about these things. So like, please don't think you're an expert or that I necessarily know everything. But yeah, when it comes to doing it, I would say the first goal is you should always, on this kind of question, find a lawyer and an accountant or a tax professional you trust, because that'll actually determine a lot of your decision making, is how you want the tax treatment to be for your personal income, because that's really a key differentiator among these forms. But as a general rule, I would say if you're looking to get outside investors, you're looking to get kind of a complex structure, we'll have a lot of employees, or you want to grow the company, then you're going to want a C Corp, which is just the standard corporation. If you're instead planning to just do something that's closely held, and it'll just be like you and maybe like one other person, like a consulting service or like a content creation, you're probably fine with just an LLC or an S corp tax treatment. I could go into that for days. I'm not going to do that here. And that way you get the limited liability protection, but you get what's known as pass-through taxation, where any earnings pass through the entity and count as your personal income. Whereas with the corporation, there's double tax because the corporation pays tax, and then any money you get has to be taxed too. So that's a general, I would say, investors, complexity, C corp for sure, simple, closely held, handful of people, LLC, S corp. Generally don't recommend a sole proprietorship, and you should always try and have some limited liability is my last point.
Is the sole proprietorship just like in terms of its limitations, is it just the liability piece?
Yeah, I mean, so your default, if you started a business tomorrow, like selling like candles, you would be a sole proprietor by default. You have to elect into being an LLC or an S corp or a partnership or anything like that. That's where you file with the state and you say like, hey, in California, New York, wherever, I'm going to enter this entity. And then you're no longer sole proprietorship. You're now well, you're not you, but you now have an entity doing the business.
Got it. And is there a point where like your business is so small you don't need an LLC, or do you recommend that at any point, even when you're just starting out?
Yeah, I'm a lawyer. I think LLCs are pretty cheap. California is the most expensive. I think it's like $800 a year, but they're crazy. I mean, like every other state, it's less than that. I think Delaware is maybe like 300-400 or something. And you get the protection of limited liability for sure. And you get some structure. So I think it's worthwhile. I mean, if someone's not willing to invest like that kind of money, then maybe they should reconsider being in business. That sounds harsh, but like, it costs money. There's no free lunch out here.
Right.
Yeah.
Do you get taxed more as an LLC or?
No, it's passed through. Yep. So every dollar that LLC earns passes through to the owners, and then you recognize it as your personal income. It literally is a separate filing you attach to your personal income returns. Again, I'm not an accountant to like clarify this, but then you're good to go.
Okay, I see. I asked because I'm a solopreneur, and I've met quite a few people asking this question all the time. So I'm glad that you can shed some light on this.
Yeah. And like I say, always reach out to lawyers and accountants about this stuff, because this is like just a free consultation will help. And then if you like them, you can sign up and work with them on other stuff. Like most lawyers and accountants will be happy to give you some basic quote unquote, but really important stuff that you need to know.
Got it. All right, let's move on to the second question.
Okay.
What are ways for startups who don't have sufficient funding to get legal assistance?
Yeah, that is a really good question. And I wish I had like a magic bullet answer and I could say like, go to like XYZ and you're done. Now, if you want like free or very low cost, there's something called pro bono, which you might have heard of, that lawyers generally give out. And that could come from certain law firms might have pro bono. Universities, like law schools, I should say, have clinics where they'll advise people for free. The caveat there, I'll say, is you're not really guaranteed quality because it's really going to be more of a training exercise. Like when I started at Cooley, I would often like do pro bono work helping people. But I was very clear, like, I'm new to this. Like, we might make some mistakes along the way. So you don't necessarily, and I would say I was on the better end because I was coming from a firm that specialized in this. What I would say on the other side is when you're talking to a lawyer, I think it's easy for me to say as a lawyer, everyone should have a lawyer and accountant to do business, because if you mess up the law, your business could be the most successful on earth, but it will fall apart. And if you mess up the taxes, your business could be the most successful on earth, but you will be paying the government way more money than you need to, and like screwing up. I mean, there's so many issues. I could go on and on. But if you talk to a lawyer, keep in mind that a lawyer can always do fee deferrals until you raise money. They can even be the one to help you raise money and not charge. So I always tell people, like, look, there's so many ways to raise money. It doesn't have to be like millions of dollars. You don't have to be in the Wall Street Journal to raise money. But even raising a few $1,000s from friends and family to get you going, and then the lawyer can either take their fee out of that, or they can defer it. Something I do often if I talk to people, and my co-founder does, is we do like a 6-month deferral, the earlier of 6 months or $100,000 raised. And even then, like, we know you're running a business, so your lawyer should be understanding and be like, hey, if you really need the cash, like we can talk later. The other thing I would advise is if you're looking for a lawyer, look for one that does more fixed fees as opposed to billable hours, because billable hours is literally what it says. It's X $100 an hour. And so if you're like, hey, help me do this, and you have no idea how much time it takes, it could literally, like, the bill could be $50, could be like 1,000. I mean, that's extreme, but that's whereas if you do fixed fee and you ask for fixed fee, people actually budget accordingly and feel like, hey, this cost me $1,000, this cost me 500. That's a really good way to manage your budget. But yeah, there's no lunch, unfortunately. If there was, well, I wouldn't have a job, but I mean, like, it's just society, America. It's not how it works right now.
Yes, got it. I didn't know about the fixed fee model, and yeah, I like that structure, fixed fee.
Yeah, I mean, that's what we do at our firm, and a lot of more firms do it. A
Mm.
lot of firms will say they don't, but like if they want your business and they want to work with you, I think they'll be amenable to it.
Oh, they don't prefer it?
Well, I think most billable hours are so common. It's been around for like 120 years now, and
Right.
lawyers at big firms have been making a lot of money for a century now. So they like that model.
I see, I see.
Which you can
Good
always
to
ask.
know.
And some attorneys might say no, and that's fine. Keep finding.
Mm,
There's not 2 attorneys in America. There's like millions of us. So
right. Good to know.
yeah.
All right, moving on to the next question. What is the difference between an employee versus an independent contractor? For example, consultant, advisor, etc., and an exempt employee versus non-exempt employee. Ooh, good
Okay.
question.
Yeah, this is one of those things that, like, literally enough ink to like flood San Francisco has been spilled on this topic. It's like one of the most litigated things. I think a key thing, if you're not aware, is an employee and an independent contractor are just two categories, the two broad categories of workers at a company. And the reason it really matters for a company and for you as an individual is employees are subject to employment laws. They're they're subject to employment laws, and at the same time, they also are subject to tax withholding and different tax structures. So, if anyone's gotten a paycheck here, which hopefully almost everyone here has at this point, you've probably seen that like a good chunk of your salary, the FICA tax comes out, and half of that's paid by your employer, half is paid by you as the employee. When you're an independent contractor, you're not beholden to all the employment and labor laws, and you don't have to pay withholding. You still have to pay tax, of course, but you do it in a different way. And the key difference, I would say, there's like 7-part tests. Every state is different. There's like a federal test and all that stuff. But I'd say the key difference is control. If you're an employee, that means that you are under the control of the company. The company says, go work on XYZ project. You go do XYZ project. Independent contractor, you're a free agent. You can like not do it. You do it at your own leisure. I think a good example of is like a lawyer, right? They're an independent contractor because if I work for a company, they can't be like, do this today. I could just be like, no, like, and walk away. You know what I mean? It's a little bit looser of a relationship. So control is the key difference there. And then exempt versus non-exempt, which a lot of people see is that's an employee still, but it's whether or not they're exempt from the labor and wage laws or not. And in order to be exempt, it's a really big deal for a startup. And if you ever are hiring someone as a startup and you don't get a lawyer, like, I'll be kind of mad. I mean, I don't know who you guys are, but like, I'll offend you. I'm not going to hurt no one already. I'm just going to send you a harshly worded email because you do not want to mess that up. Exempt means that the person is performing kind of like executive, professional functions, and they're usually being paid a minimum salary, which varies by state. So like nationwide is like $36,000 a year. In California, I think it's up to like 58, 60,000. Like New York is maybe like 50,000. I don't know. It just varies by state. And then non-exempt is a person who's subject to all the things you hear about, like hourly wages, overtime, meal breaks, like all the things. And for a company, you generally don't want non-exempt employees if you're a startup because it's an administrative nightmare keeping track of like people's hours and overtime rates and like meal breaks. And if you mess them up, it's like you can get seriously penalized. And it's very easy to mess them up because there's a lot of rules. that take care of people. So an exempt employee versus non-exempt is a very important distinction, and you want to make sure that as much as possible, your employees are exempt, I would say, especially in a startup. And you also want to be
And
one. You get more money.
right.
Yeah.
What's the pro of having non-exempt employees?
It's more like this is going to sound bad, cheaper. I mean, the people, you pay them less because you only have to
Okay.
pay a minimum wage based on that state. And then you do have overtime. So I'd say a non-exempt is more for someone who kind of just wants to do, I don't know how to say this without being mean, but like more menial tasks, like not necessarily like more professional work or executive level work or administrative. Um, so that's the difference. Like an intern would be a good example. That's a little different. They would be a good example
Okay.
of someone who probably want to be non-exempt because they don't, they just help out on projects. They're not like a key cog in the machine or anything like that.
I
They're
see.
just there.
But
Yeah.
they're still considered employee. They're not contractors. They're still employees.
Yeah, they get paid. I mean, they're a little different because they're temporary employees. That's another thing too. People get confused. You don't have to be full-time to be an employee. You can be
Mm,
part-time, you can be temporary, you could be flexible. There's all different arrangements. It's really just the control piece. If the company's controlling your work and they're making you use their equipment and they're telling you when to work and where to work and how to work, you're an
yeah.
employee. Even if you call yourself a contractor, the government does not care. And I should also add, the reason you don't want to mess this up is the penalties are extremely steep, obviously, because the government is like, you're avoiding taxes. You're not paying us
Mm,
our employment, all that stuff. And then on top of it, like litigation is intense and expensive. So as a company, you don't want to
mm,
mess up the classification. Obviously, people like work in the gray here, but it's not the kind
mm.
of thing you want to mess up for sure. That makes
Got it.
sense.
So does that mean that a company pays more taxes when they hire employees?
Yeah, generally, yeah, because you have
Okay.
withholding, usually paying them more money, and
Mm,
keep in mind too is if you fire a consultant or terminate one, I'll say the nice legal term for letting someone go, um, then it's a lot cleaner because usually the agreement's like, hey, we can end this like 5 days notice. An employee, there are
mm,
so many there are so many laws protecting employees. Yeah, obviously,
mm.
employee law, you can't fire it. Like, I know it goes to another question we have coming up. But it's a lot easier to get rid of a contractor too than an employee. An employee usually have
Got
to pay
it.
some severance and like they're entitled to leave benefits. It's messy.
And
So
for exempt employee versus non-exempt employee, do companies pay more for exempt employees?
generally, because yeah, you have
Oh.
to pay a minimum salary for an exempt
Mm,
employee, and
mm,
that's and that has to be every 2 weeks. They are owed 1/26th of that salary. So like I was saying, California I think is about $60,000 a year,
mhm,
and software engineers actually in California I think it's like 90 to 100,000. I have to double
mm,
check because every year it
mhm,
goes up a bit. Um, so yeah, you pay more for them.
I see.
Yeah.
Good
But
question.
also you don't have to deal with a lot of as many labor laws. So that's like the trade-off. And this is why I'm saying like this is one of those
Oh,
things where you don't talk to a lawyer, like I'll be mad because like it's so fact dependent and
yeah.
you'll hear me say this a lot, but a lawyer's favorite term is it depends. And it's really true. Depends. I'm trying to give good answers, but like I don't have if I had a perfect 2-sentence summary, I would be on the Supreme Court. So it's fine.
Got it. Ooh, learned so much already from this one question. All right, moving
Oh,
on to the next question. What is at will employment? We hear this all the time. What does that mean?
no, it's good. So it's the American default standard. I'm pretty sure every state, definitely California, definitely all the big states, it's the default rule that if you and I enter into an employment relationship, it's at will. Meaning, if I'm the employee, I can quit anytime for any reason, any moment. I could just be like, I don't want to do this and walk away. And if you are the employer, you can fire me for any non-discriminatory reason at any time or whatever. So you could fire me right now because I don't know, you're just like, I don't really want you around. Like, bye. Now, of course, the caveat is an employer cannot fire an employee for discriminatory stuff, which is like things we all know, like race, gender, sexual orientation. You can't do that. But in certain states like California, New York, I mean, California is I think the most extensive. it's
Mm.
dozens of categories. Like California, you
Mm.
can't fire someone because you think they're like fat. You can't fire someone because they're like a parent. You can't fire someone because
Mm.
they had an abortion. Like it, the
Mm.
list is extremely long, and that goes back to why employee independent contractor is kind of fraught with issues. Is if you're firing someone, an employee, there's so much risk you have to navigate and make sure you're doing it in the most kosher, clean way possible.
Mm.
And even if you have no ill intent, if there's an impression of intent, especially in a state like California, you're open
Mm.
to a lot of litigation, you're open to like a lot of risks. I mean, it's so you really need a lawyer to help you navigate all the process of getting rid of
Mm.
stuff. And I know I'm saying this like lawyers do everything, but like this is one thing where like you should these are all sensitive things, and this is one thing for
Mm.
sure I think a lawyer can help with.
So if you're an employee and you got terminated and you
Mhm.
feel it was unfair termination, that means we should be talking to a lawyer as well.
Yeah, you can. I mean, so I will say there's a difference between being like fired for poor performance and
Mm.
like I felt like I did good performance. That's not protected. But
Mm.
if it's fired because I don't know, this person seems to fire only women or like only fire like Asian women, that like
Mm.
that's a potential issue. Um, and I'm not an employment litigator, so I
Mm.
wouldn't be able to like me personally, but yeah, there are litigators out there. And you also have to weigh the costs. Like, if you're an employee, do you really want to rock the boat? Because you have to get another
Mm.
job. But if something really egregious happened to you, the law, California is extremely protective, and really a lot of other states where people might be calling in from, like New York, Illinois, have very similar laws too. And frankly, I always feel like California has the most laws, but it's kind of leads the way. Like what California does, everyone else will adopt within 15, 20
Mm.
years. California is just like really progressive. Not
I
trying to be
see.
political, but yeah. Um,
Is California the most progressive state?
I would say so. I don't know all
Mm.
50. California is way up there. I consider
Okay.
considering how important California's economy and how many people live here, it's definitely the most impactful, I think is a fair
Mm.
yeah.
Got it. What is the difference between a litigator and a lawyer?
It's a great question. And there, yeah, I'd
Sorry,
say
that's
if you
not on the script.
no, no, hey,
But you
I'm
mentioned
asking,
you're not a litigator.
yeah, I'm not going to be mean to litigators because I am not one. So litigators are the people, but my parents still think I am. They always ask me like I'm going to court. I'm like, I don't do that. But litigators go to court. Litigators are confrontational. You say like they represent defendants, plaintiffs, litigants in a civil or criminal case or whatever.
Wait, they're not lawyers?
No, they are lawyers. I'm sorry. There's two
Oh,
classes.
sorry.
There's
Oh, okay.
no. I'm apologies. I'm not explaining this well. Yeah, there's litigators, and then I would call them like corporate or like transactional attorneys is the other category, which is what I fall into. So I represent businesses. I help their interests. I protect them from the like legal liabilities. Litigators are the ones you go to them when you're like, I want to sue this person, or I'm being
Oh.
sued by the government because I committed a crime or something. And this is really broad, and if there's any litigators, I hope this doesn't trigger them. But I kind of look at litigators as like fighting, whereas transactional attorneys like me, we're more like, hey, let's just get along. Like, let's just like build this beautiful pie together, and I'll take our slices. That's the dream. We do not like fighting, and if we do our jobs well, you should never talk to a litigator. But
Oh.
yeah, that's our goal. Sorry, any litigators. You guys are great. Don't sue me.
I I'm such a noob because I thought all lawyers go to court.
Well, we can, like, I could, but it's, like, such a distinction. Some people do, like, if you guys see the show Suits, they do everything. That's not realistic, especially at a good law
Oh,
firm. Um,
okay.
litigation's, like, a whole 'nother world, and there's a whole pattern and stuff, and, like, they learn that, and then corporate transactional people learn another one. But I could go to
Oh.
court, like, it's actually helped me a lot. Like, if I ever have, like, a dispute or something like that, I can just tell them I'm a lawyer, and everyone thinks, like, "Oh, this guy's gonna, like, sue me." It's like, hope none of these people I would threaten this to are on the call, but no, I really don't know how. Like, I could figure it out. It'd not be fun for me.
Oh, wow. So let's say I work with you. You're my lawyer for either my employment issues or for my startup.
Mhm,
But either I want to sue someone or someone sues me. Do I
mhm.
have to work with a different lawyer now? and not
You,
with you? Or
you depends. I don't want to say all lawyers, but like it was me. Yeah, me and this other guy, we would refer you to someone for litigation. But something to keep in
oh.
mind too is, your company, especially as it grows, or even just in your life, you're not going to have one lawyer for everything. Most 99.99% of the time. But that's good. Lawyers like working with other lawyers. The whole point of our legal system, the way the ecosystem works, is we all kind of specialize in different pies. I'm general corporate, so I touch a lot of things. But
Mm,
wanted something with patents. We will find you a patent attorney, and we will work closely with them to make sure
mm,
their work for patents matches really well with our corporate stuff. If you wanted
mm,
like immigration as a good example, like I don't do that. It's very specialized and very important. We'd work with an immigration. So like an example is like think of Google, right? Like they have teams of lawyers and teams of outside lawyers that do everything. And no one person does it all because that's
mm.
impossible and probably malpractice if they say they could.
I
Yeah.
see. Outside
Yeah.
lawyers, so that means they're not employed by
Yeah.
Google,
Yeah.
like in that
So,
example. Ah,
yeah,
okay, got it.
exactly. 'Cause Google actually has employee lawyers on staff. They're employees, not independent contractors at Google.
Mm.
Tying it back, you see, yeah, again,
Good job,
lessons.
Alex.
Lessons.
All right.
Yeah.
Moving on to the next question. What types of screening methods can an employer use for me? Am I legally obligated to disclose my present salary to a prospective employer?
Yeah, great questions. Get them all the time. So I'll answer the last one first because that one's probably the quickest and cleanest. So depends on your state. I want to say that I'm a California attorney, so I can work. I just know California employment laws, although I can work with people pretty much in any state. But in California and a lot of other states, like I believe New York, a lot of the bigger, more like liberal states,
Mm,
um, an employer is not allowed to ask you for your prior salary. It's equivalent to a lawyer asking you like something very personal, like what's your credit history? Like they're just not allowed to do that. If they
mm,
do that, you can reject them. I mean, technically you could file a claim, but whatever, that's a conversation for another day. You can refuse to answer. That said, if you voluntarily give them your prior salary,
mm,
they can then use that in determining whether or not to hire you. So
mm,
be really careful with that information. If you're in California or other place, again, I'm saying this, talk to a lawyer just so they can help you explain like your rights in the state you're in, because that's really what governs. State law governs more or less a lot of employment law, especially on like in states like California that have probably more employment laws than the federal government. Um, so you do that. Now, another really nice thing is in California, Colorado for sure, a few other states, this is becoming more, you might have seen this if you guys look at job postings. It's now required that they have to put a pay range on the job,
yeah,
usually
yeah.
within like 50 to 70,000. So that's how you can kind of like feel out if this job is like in your range. So if you were getting paid like 200,000 before and this new job is like 75 to 125, probably not going to be able to negotiate that up. So that's, there's pay disclosures more common.
Mm,
When it's kind of screening you can use, an employer can use for me. Again, I'm going to do more California, but that applies to like what 15% of the country, and a lot of other states follow the same thing. Is they can do background checks, they can do reference checks. Reference checks being they call up your old employer. Most employers, by the way, will have a policy that other than saying confirming you work there and your dates of employment, just to make sure it matches your resume more or less. Um, they're going to have like a policy of we don't really disclose more than that because they don't want any liability for the
mm,
most part. And there's
mm,
exceptions. Like if you have a violent history, the old employer will be like, yeah, this guy is violent. They have to tell them, otherwise they'll be liable.
mm,
But they can't ask for your credit history. And in California and a lot of other states, there's this movement. If you Google it, it's called Ban the Box. It's the idea that so many people in America, because we're such a criminal law society, have records. You're now no longer to go back, especially in California, for example, and get previous convictions, arrest history. Any convictions older than 7 years cannot be on your
mm.
record, regardless of what it is, unless it like directly. There's always exemptions. So I'm like really simplifying this, and there might be one labor lawyer who's like shaking their head. I'm sorry. I'm trying to get there. Yeah, so there's this ban the box movement. Another thing I will say too is that lawyers can scrub your social media. That's pretty much allowed, but
Mm,
they can't. I don't know how you would prove this, but they can't discriminate based on things. So if on social media you show you're at a pride parade, or you show
mhm,
you're orientation, you're homosexual or whatever,
Mhm.
and they don't hire you as a result of that, that's not. But the problem is, how are you going to prove that they like?
Right.
Yeah. So
Yeah.
just, I mean, be careful on social media. That's public. You're putting that out in the world. Like, that is available for anyone to see, unless you have a private
Yeah.
account.
Right. Food for thought for sure. Alrighty. Next question.
Mhm.
What is FMLA, CFRA,
Mhm.
and PDL law? What are their key benefits?
Yeah, this is like the alphabet soup portion of the law. Gets pretty wild. So people should know FMLA is the federal law for family medical leave stuff, and that is every state. It's the minimum. It's the bare minimum.
Mm.
I'll talk about the California stuff just because I'm a California attorney. I know it the best, but you can obviously work with other states. So if you're New York or something like that, you can find a New York attorney or talk to me and someone else who works there. In California, the CIFRA is California's version of the FMLA, and the PDL is California's bolstered version of the pregnancy disability protections under the CIFRA, if that makes sense.
Oh, I
So
see.
yeah, okay. I mean, well, so I put it this way: like, all three provide you with job protection, but not pay protection. Like, you're not going to get paid, but they give you guaranteed leave for various things. So the FMLA and the CIFRA, they apply to any company that has more than 50 employees. Like, it's the baseline, and you have to have worked there for last 12 months, and I think like worked over like 1,250 hours in the last year to be eligible. But what it basically means, if you have certain things like, and it's not even disability, it could be like you have to take care of a spouse or a family member who's got a serious health issue. You need parental leave, which, maternity, paternity leave, all that stuff. If you have your own serious health condition, and pregnancy under CIFRA is actually considered a serious health condition as a father of two, I can totally agree with that. And so what it lets you do is CIFRA and FMLA each give you 12 weeks of protected job. So it means when you are on leave, you're guaranteed 12 weeks leave. It'll be unpaid. Employer can pay you if they want. But when you come back, you're entitled to an equivalent position with equivalent pay and benefits. So basically, they can't fire you because you had a baby or your child got sick and you needed to watch them for up to 12 weeks. The PDL is California's law. It gives you actually 4 months, which is really awesome. So if you are not recovering well, or like the pregnancy is particularly hard, or you just want more time with your child, like there's all kinds of things, then you can get 4 months. And the nice thing in California is there's something else, not to add more, but it's called the paid family leave. You can actually get up to 8 weeks of partial wage reimbursement. Again, I know I keep saying it, but like, this is the kind of stuff that's like really complex, and like just making sure you talk to a lawyer so you know what laws apply to you and how you can take advantage of them. Nice thing too is, in a lot of states like California, New York, Illinois, I know when I'm doing the big like liberal states or whatever, but I'd say the norm is more and more that FMLA is like the floor, and companies will go above it. Like, for example, my wife works at Microsoft, and she got 24 weeks paid leave. So that's like way better than, I know it's the dream. We should have another kid just for that, but that'd be a terrible decision in our lives. Yeah, got enough for now. So these are just the floors, but like understanding your rights and preferences, and frankly, these laws have been around for so long now that an employer would have to be brain dead to like fire you because you're on leave at this point. When this came out years ago, it's probably groundbreaking, changed society. I feel like society has changed so much that these laws are almost like not up to snuff. Like, they're not even up to today's culture. So they'll probably be revised over the next, like, I don't know, 15, 20 years. We'll see what happens.
Do these leaves stack on top of one another, or they cancel it out? So FMLA, you said we get how many weeks? And
12,
then
12, it's
12.
12, 12, 4 months.
Yeah, so do they stack?
Yeah,
So
they
it's
can.
4 plus
There's
4 plus 12.
So no, the FMLA and the CIFRA are together, but the PDL and the CIFRA and the FMLA overlaps for up to the first
Oh.
12 weeks, and you get the PDL on the back end.
Oh, okay, I see.
Yeah. So there's like different ways you watch it. It's also, you don't have to do them consecutively, is a really important piece. Is you don't have to be like, I'm out for 12 weeks. You could do like 3 weeks, 6
Right.
weeks, 3 weeks, or you could just do 5 weeks. You don't have to do 12, you know? You just
Right.
have up to that amount and you're guaranteed protected. And your employer could also agree to whatever you want. Like you could do like, I don't know, a year off. It's not going to happen, but technically that's possible.
You said employers can't fire people
Mhm.
as a result of um,
Oh, like taking leave.
like right. But we hear that people can get laid off. Why is
Yeah.
that?
So difference is a layoff versus firing someone because they took leave. It's the intent. So a layoff, or you might hear reduction in force, that's a broader thing. And the underlying goal there is economics. So the excuse is like, we're not firing these people because of their race, gender, you know, their paternity
Mm,
leave. We're firing them because we need to reduce costs. And we're like cutting X percent, like Google, right? Like they did on Facebook, they did like 5-10% of their workforce. It was just a
mhm,
cut across the board. And the rationale was economic. And there's no
mm,
legal protection that an employer can't fire you for economic reasons. The issue,
mm,
though, of course, is, and I'm sure their lawyers were working really hard and made some really good billable hours at Google and Facebook, is they had to navigate to make sure, like, hey, let's just make sure, like, you know, we don't fire all women, or like, you know, like, or we don't fire all like LGBTQ plus folks.
mhm,
Um, and even if you're on leave, you're still actually entitled to payout. But usually, what they would do is they would just pay you out the remainder of your leave, and
mm,
then let you go. I mean, that's again why you need a lawyer, because you need a narrative if you're representing the company, explaining like why these firings or layoffs or rifts were
mhm,
legitimate. Um, and honestly, I guarantee you, Google and Facebook got sued by someone, because there's no way you lay off
mm,
thousands of people and someone doesn't find cause. And you could sue for anything. I could sue you tomorrow just for like, I don't know, your headphones trigger. Like it's insane stuff, but I could sue you. So just keep in mind, like you're never litigation proof. You just want to have as
mm,
strong defense as possible in advance and a narrative in
mm.
advance. Lawyers matter for that.
Interesting.
Yeah.
Okay, moving right
Okay.
along. We're a little
Mhm.
bit behind on time.
Oh,
Um,
all right.
all right, so let's go. What types of agreements will an employer ask me to sign to protect its IP?
Okay. Well, I'll try and speed up my answers. Sorry, I'm talking so much. I think this one's faster.
No.
What you'll usually get is an agreement. It's called a confidential information and invention assignment agreement. It's like, I'm saying so many letters, I feel bad. CIIAA, or might be called a proprietary information and invention assignment, PIIA, whatever. Basically, you're going to have an agreement called something that's going to give two things: confidentiality, that anything you work on in the company you're going to keep confidential, like any. And the
Mm,
second, which is really really important for both the employee and the employer, is any work you do on behalf of the company, you assign that work to the company. So if you invent
mhm,
something, if you come up with a great idea, if you develop some formula, you build a spreadsheet, it is not yours, it is the company's. And that's so important, because if you're the company, you want to make sure you own all the important stuff in your
mhm,
business. Right? Like you don't want your employee to be like, oh, I built this product, like bye, you know, and you can sue them and be like, no, you gave that to the company owns that. And for the employee, it's really, really important. I would say there's a section where you have to list prior inventions. So if you do have patents or you do have certain things that
mm,
you really want, you can exclude that from the, like, imagine, I don't know, you're working at Google, but you have a patent and you're like, or you want to develop something and you have this idea for a startup you want to do in 3 years. You
yeah.
can list that as a disclosure, and then that's excluded from the invention assignment. So when you start that new company, Google has no grounds to, I mean, they might still do it, to be like, hey, that's ours. You worked on that while you were here. Because no, it's like, no, I excluded that. Like, that's not part of the agreement. So
Mm,
that's really another thing too. It's state specific. So like
oh,
California, for example, you can't do non-competes, you can't do non-solicits. So if you ever see that in one of these agreements, you can ignore it. You can also tell them to like go to hell, because it doesn't apply to you, which I would recommend, because that's kind of rude, to be honest.
does it mean that we don't need to sign it, or we could just sign it anyway since California doesn't recognize it?
I would push back just so there's no. Well, first of all, it's a bad sign to me if you get a CIIAA or whatever one of these agreements, and you're a California employee and it has a
Mm,
non-compete. That's a
mm,
sign to me that their legal team or their company has no idea
mm,
what they're doing, because that's like such low hanging fruit. And you just don't want to give
mm,
any argument for a non compete. It's the thing. Like, just take it out. You know, don't.
mhm,
And it's very easy for them. It doesn't apply. So just take it out.
got it.
You know, it's up to you, of course. And like
Yeah.
each, yeah.
Um, let's say I work at Google and I
Mhm.
have an idea, but it has nothing to do with my work, and I
Yeah.
get my idea patented. Does Google own it?
Mm, depends. I know I say that. So as long, and actually, I think one of the other questions talks about like side hustles. So we can maybe
Oh, yeah,
probably,
yeah.
yeah, maybe we could
Oh,
go,
wait,
but
that is actually literally the next question.
yes, we're so in sync right now. Yeah. So like I was saying, it really depends. Now I will say, keep in mind that if you're an employee, you always have a fiduciary duty to, which means duty of loyalty. You have to care, you have to be loyal, all that stuff to your
Mm,
employer. A side hustle idea is fine if the IP is really different from whatever Google's working on, then Google probably won't have a claim. That said,
mm,
I would generally advise you should disclose any side work you're doing or ideas you're doing or like working on and stuff like that. That way it kind of covers a two-way. One is you avoid like getting fired, because if Google
mm,
finds out you're working on something else and they feel like you're not performing up to expectations at your job, it's an easy excuse for them to be like, you're not doing your job. Like, you're out of here. So that sucks.
mm,
The second one is it'll help avoid disputes about IP, because if you get it cleared, or intellectual property IP, if you get it cleared with the company you're working at before you start working on it, then it's kind of hard for the company to come back later and say like that was ours. And a key thing too is, as long as you're doing things like avoiding working on it on the company's computers and materials, if you're not using any company materials at all, like anything owned, unless you like bought it off the shelf, like you're not using any Google software that's not like purchasable somewhere, then you should be fine generally. But that's again another area where it depends, and a lawyer is really valuable to make sure your IP is protected, because the two things that will mess up the company are bad IP and bad equity structure, which is stock structure. Yeah.
I have a question on the side hustle thing. So, uh, let's say let's pretend I still work at Roku. I don't anymore, but let's pretend I still work there, and I want to teach a course on how to be a good product manager,
Mm-hmm.
and that course is my side hustle. Is there any
Yeah,
conflict there?
depends. I mean, if you're not giving, if the presentation materials didn't come from Roku, if you're not using any Roku information, if you're not mentioning Roku,
Mhm,
probably fine. But that
mhm,
said, even for you, just going, in your imaginary manager, pretending, just talk to them and be like, hey, I want to do this on the side.
mm,
Disclosure is not a bad thing, as long as you're not
mm,
disclosing after the fact. I really think this is like one
mm,
of those. I'm not trying to be. I think I'm a more practical lawyer than most, but I always recommend
mhm,
people, when it comes to this stuff, don't ask forgiveness, not permission. This is the one time where I would go the other way.
mm. I see.
Disclose. I mean, you can always not, and grand scheme of things, Roku's probably not going to come after you, but
Mm,
don't give them an excuse to be upset at you. Because
mhm.
like, what's the point?
Got it.
You don't have to give them full details. You don't have to give them like access to your
Mm,
deck and everything. You just
right.
tell them like, hey, I'm planning to do this. It'll be it will not interfere with my day job. It'll be
Yeah,
off hours, all that kind of stuff.
got it. Good to know.
Yeah.
But they if they want more information about the course, I would need to disclose that, right?
It would be, yeah. I mean, if they ask for it, yeah. But I think it's innocuous, not
Okay,
painful. It shouldn't be a problem. Yeah.
got it. Alrighty,
Yeah.
next question.
There you go.
What types of equity should I ask for? Options,
Yeah.
restricted stock awards, restricted stock units, etc. Oh, I didn't know about the awards part of it. Okay.
Yeah, there's so many out there. There's like 5 or 6 different key.
Oh.
So, again, it depends. And like, I would say of all the topics we talked about, equity is one of those that has probably the most to go with, other than like independent contractor versus employee.
Hmm.
So it depends. But my general rule is, the earlier stage a company is, the cheaper its stock is, the more you want to be purchasing that stock. So that could be restricted stock awards, which is
Mm,
basically stock. And then the restriction is that if you leave before the vesting is done, we buy
mm,
back the unvested shares, or you
mm.
give them back to us, basically. It could also be options with early exercise, which you might have heard of. You can get
Right.
options and you can just exercise them before they vested. In that case, the vesting is, you can't exercise until the vesting hits. Early exercise like says, don't worry about the vesting. Like, I can
Mm,
exercise today, but if I
mm,
leave before that vesting hits, I have to give back the stock. that didn't vest. And so I say, as a general rule, earlier stage, you want to own the stock because it's so cheap. And there's also this
Yeah.
thing called an E3B election, which some of you might have heard of. If not, don't read it on the tax code. Your eyes will glaze over and you'll fall asleep. But what it basically does is let you accelerate your tax liability and recognition. So if you have an RSA, could feasibly pay no tax if you ever sell the stock in the future because you've already seen the income on it. Well, I mean, you do pay a little tax. Long story. But way less. And if you're a mid to later stage, you're probably gonna have no choice but options or restricted stock units, which are kind of similar. A restricted stock unit is just a promise to give you stock at a certain price in the future, but you don't get it until it vests.
Right.
They're nice. I mean, but again, I'd say restricted stock awards, options with early exercise if possible, and the price isn't too high. If you're looking at like $1 a share, you have 100,000 shares, that means you have to pay $100,000. But if the shares are 0.0001 per share and you have 100,000 shares, you're talking about like $10. I would just pay $10 for 100,000 shares. That's a pretty good deal.
Got it.
Yeah.
What's the difference between stock awards and stock units?
Oh yeah. So stock awards are you actually get the stock. Like I buy the stock, like mine now. It's an award. Like, hey, here's your stock. Got it. It's just restriction is if it doesn't vest, then I have to give back the invested. Restricted stock unit is just it's different. I don't actually get the stock. I'm getting a promise to future stock. It's like the inverse. That's more a later stage thing. If you're at like a big company like a Google, Facebook, they often give restricted stock units because there's so many tax reasons and like securities laws issues. But it's a lot cleaner to do that. Early stage is options and restricted stock are like your two go-tos. Yeah.
Got it. Okay, next question. What benefits can you negotiate at a large company versus at a startup?
Yeah, it was a great question. I'd say a large company, as you guys probably know from experience, not a lot of leeway because they have a very set way of doing things. That said, at a large company, you do have, because they have more resources and more flexibility. If you have a good relationship with your manager, I think you can negotiate almost anything. It just might not be written down. It might just be in emails or whatever like that. So that on the reverse side, a startup, I always tell people to go for it. Like, think of it this way, like a startup is, it's like, that saying like they're building a plane while flying it or whatever like that. Like they're too busy trying to stay in the air. If you have a reasonable request, like, hey, look, I know you want us in the office 5 days a week, but I have kids, like I can only come in 2, like ask for it. If you're like, I like a signing bonus because I'm leaving a cushy job and I just like $10,000 extra cash up front, go for it. Like startups are way more amenable in general because frankly, they don't have the luxury of like time and resource. They don't have as many resources, but time is not one of them. That's my general rule. You can negotiate anything, but like, as long as it's legal, like.
Good to know. Good to know.
Yeah.
Next question. What should I negotiate? How should I negotiate severance after a long tenure at a company?
Yeah, anytime it comes to severance, I mean, it's always a touchy subject. The thing I would always recommend employees remember is you're kind of in the driver's seat when you're getting terminated. Like it sucks. It's emotionally draining. No one wants to get let go. And a company probably doesn't want to let you go. But if you do, you have the power because they will probably want to pay for your silence or pay for your not suing them, right? Because you're a huge risk. If you get fired, you could, in California especially, you could sue for anything. Like maybe not me as like a white male, but I guess I'm Jewish, so I don't know. There's all kinds of like protected classes, but everyone in California falls under some protected class, which means every single person when they get fired is some form of liability. Just keep that in mind. And the longer tenure you're at a company, even more leverage you have because you've seen more stuff. You're a much more credible witness. If you're someone who got fired after 2 days, it's kind of hard to be like, they discriminated against me. If you've been fired after being there for 10 years, it's a lot easier for an fired employee to like build a case. Now, I'm not saying you like threaten, of course, don't do anything immoral but yeah, you're in the driver's seat because they're trying to pay for you to not sue them and to try and stay quiet. And they really want that for their own protection, especially an early stage company. And just like, don't cave. And if you want more severance, ask for it. Like it's your kind of being fired and being hired, like the 2 times you have leverage as an employee.
Well, what's a good reason or what's a good justification to ask for more severance?
Well, I think if whatever they offer you, you don't think is fair, Like if you give up like a high paying job to come to this startup, the startup fires you after 3 months, you're like, well, that's not fair. I gave up this other job. It was worth more money. Like you're going to have to pay me like X months additional. If you think they're lowballing you, because you're like, hey, no, I developed a lot of stuff here. I built like a lot of value in this company. You're not compensating me fairly for that. You're trying to get out of paying the rest of my salary. It's really whatever you can. That's why talking to a lawyer is nice, because you have this nice third party who can just see it with clear eyes. There's no emotion on our end. It can be a friend, but I would always talk to an attorney because they know the law and can be like, no, you deserve this. Here's why. Don't negotiate by yourself. That's sad. No one wants that. Yeah.
Good to know. All right. Next question. How do we negotiate salary, particularly sign-on or annual bonuses and parental benefits, and ensure the employer isn't lowballing?
Yeah. Well, so the nice thing on the last part, lowballing, kind of mentioned before, but California and a lot of states have to publish the range, and it's getting tighter. So you'll just be able to know what your salary range is going to be. When it comes to sign-on annual bonus, my biggest advice is talk to current or like recently departed employees. You can share anything you want about salary. And in fact, employees should talk more openly about, this is not a new thought. I'm not like, not like Martin Luther King here, like coming up with something new. People should be talking more about their salaries and like their bonuses. Like ask a friend at the company. Most likely if you're joining a company, you probably know someone who's already there, or like 2 degrees of separation. Ask them like, hey, what did you get for sign-on bonus? Did you hear about any other sign-on bonus? The annual bonus plan. And you can use that as a negotiating point. Also, keep in mind, like I said, being fired and being hired are your 2 most important parts of leverage. Hiring and firing employees is super time. If the company's doing it right, is super time intensive, very like, there's just so many factors that go into it. They've invested so many resources into this already. They're going to want to make sure that like you're happy to get you over the finish line. I mean, don't go crazy. Don't be like, I want like a $10 million signing bonus if you're like just like a regular software engineer. You could ask, but I think a company would be crazy. For general stuff like, 5,000, 10,000 signing bonus. If you're moving, I would like moving costs covered. Airbnb hotel paid for like a couple weeks, something like that. Like very fair things. If you can justify it, they ask for it. And again, having a third party, a lawyer, a really good friend, just gut check you, because I fall into this trap all the time myself. Like I get emotional. I'm like, oh, I don't want to like upset people, but get a third party who can be like, what are you talking about, man? Like you work your butt off. Like you deserve this. Like it's a fair ask. Go for it. And then you'll feel more comfortable doing it. So that's my advice, generally.
Got it. I never thought that I could just talk to a lawyer on all these different topics.
Yeah. Hey, we're just people too. We're just business partners. Not litigators. They'll just like try to get you in court.
Now I know.
Yeah. Stay away. No, they're great people.
All right. Next question. Let's see if we could answer 3 more questions in 5 minutes. Ooh, challenge. Oh, we already did this one. Okay, so it's just 2 more questions. Oh, okay, we could totally do it. What order should I negotiate components of an offer letter? Base, bonuses, equity, etc.
Yeah. So again, it depends big time. My general advice is I think you should always prioritize cash first. Cash is king for a reason. You can use cash and you can go buy things and you can exchange them for goods and services, and you can buy stock and you can buy other things. So I would say cash. The second one, I would say second and third, I would say negotiate benefits if they like are important to you, like parental leave. If you have kids, make sure you get those benefits down. Like, yeah, maybe you don't care about like, I don't know, a company's gym plan because you're like, I'm too tired, I have kids or something. Or maybe you really do care about the gym plan. Those next, just the benefits that really matter to you, like a 401k match is really important. You might not be able to get anywhere, but can't hurt to ask. The third I would say is honestly equity, because stock sounds cool and like, but I look at stock as like, especially in a startup, it's kind of like a lottery ticket. Like, even if it's worth something on paper, you can't sell it until the company's public or it's sold. And even then, there's something called a lockup where you have to hold the stock for 180 days. So like stock's cool, but like unless you're getting in the growing, unless like you're going to DoorDash and they're going to IPO next year,
Right.
then maybe, but even then, IPOs aren't guaranteed. You're not guaranteed your stock will ever be worth anything or even sellable. So
Right.
I always count them third. And then the last one I would say is like benefits that you are like okay to have. Like,
Mm.
I don't know, like a commuter pass. If you don't commute, like I don't care. Like, sure, you know. So
Mhm.
anyway, cash, really important benefits to you, and then equity, I would say, are the order I would go. But of course, it depends. Everyone's life's different.
Got it. All right, last question.
Oh man.
How does one
All right.
choose a lawyer? What are some tips on deciding whom to go with?
Yeah. Well, thank you everyone who's been like letting me. Lawyers never get to talk, so when we do, we talk a lot. But we're just behind our computers getting shouted at by people, so it's a little nice to have like friendly faces. But I would say like the two or three things, and it doesn't have to be me. I'm not saying like I'm God's gift to law. I'm not gonna like pretend. But I think one is you really got to like the person. Keep in mind,
Mhm.
like you're talking to a lawyer or it's a long-term relationship. This is someone you're gonna have to like open up to. This is someone you're gonna have to tell like some stuff you probably don't even want to tell like your other family members or like
Mhm.
confidential and stuff. But at the same time, you just don't want to like be dealing with a jerk or someone you don't respect as a
Mhm.
person. So I would say that it's really like you're looking for like a business partner.
Yeah.
Second thing I would say is you probably want someone who just doesn't know, not just knows the law, but has experience applying it. Because I could tell like any of us here can read the law. The question is like, who here has seen the law in action? Like they
Mm.
know which provision actually matters in a contract. Like any high school student can understand what like indemnification clause is if they read it. It's like who's going to be like, well, here's how it has to be written to make it the most protective for you. So
Mm.
getting the experience really matters. So someone who's got like at least a few years of working in that field or is really smart and you feel like is just a good intuitive common sense person. And then the last one, which I think a lot of people don't prioritize, but they should, is kind of responsiveness. If you have a
Mm.
lawyer who's a great guy, is super smart, or girl, sorry, or gal, and has amazing experience, but they don't respond to you quickly, like
Mm.
quickly as a couple days, they're not
Mm.
communicative, I would just walk away. I mean, I think it's like the easiest part about being a lawyer is just being attentive. It's a service
Mm.
industry. Like, if you ordered at McDonald's and they didn't get back to you for like 5 days, you'd probably be like, I'm not going back there. I don't know why people put up with lawyers. So you want a lawyer who's like responsive too, I'd say. That's the
Got
last
it.
piece. That's how you foster a really good relationship with a lawyer, I
Should
think.
we see lawyer as a friend?
Maybe not a friend, but like I mean, they could be friendly, but a trusted,
Okay.
maybe like a mentor. Doesn't have to be a
Mhm.
friend. Someone
Mm.
who's opinion you value. Lawyer doesn't have to be a mentor, but in a way they are a mentor because they're helping you
Yeah.
navigate a legal world. They're
Right.
your guide to the legal landscape. So
Yeah.
I would think of it that way.
Got it.
A friend actually could be a little tough, like if you're like, but because you have personal dynamics, but
Yeah.
it's doable. Yeah.
Got it. Um, how does one go about switching lawyers? Like, let's say
Oh,
I have a
well,
lawyer who is not responsive and I should walk away. Like, how does that work? Do you exchange paperwork? When I say,
yeah,
okay,
it's
give
well,
give all my paperwork to my new lawyer.
yeah, that's kinda it. Well, what I would say is
Uh,
always talk to your lawyer first before firing him. You just never know. Like, maybe they're not
okay.
responsive for 5 days because, like, I don't know, their wife got in an accident. I mean, if I was them, probably, like, should just email being like, "I'm sorry, I have a personal commitment." Just
Yeah.
doesn't have to be responsive as in, "Here's your work." It's like, just responding being
Mm.
like, "Thank you, email received. I'll get back to you soon. We'll talk."
Mhm.
Talk to
Mhm.
your lawyer. You never know what's going on. We're all people
Mm.
too. Like, we're not
Mm.
machines. But yeah, in California, every state, the way it works is you are the boss. You can hire your lawyer anytime you want. You can work with other lawyers, unless your
Mhm.
lawyer says it has to be exclusive, but very few do that. And yeah,
Mm.
if I was your lawyer and you fired me, we had good, we'd part well, amicable. I would transition the work that we've been working on to the new lawyer. It is your work. It
Okay.
is not mine, if that makes sense.
Okay.
Like,
Got it.
so yeah,
Good to
there's tons of
know.
ethical rules. We all have to take this test called the MCLE, which is like just a real pain in the butt. But lawyers have to learn the ethics rules over and over again. It's on the bar exam too. So
Yeah.
yeah,
Got it.
you're fine. Everyone follows the same set.
We have a nice comment. Let me bring it up.
Thank you.
Thank you for coming to our live stream.
Mhm.
And with that, let's, before we go, Just want to remind everyone this is how you could get in touch with Alex. Scan the QR code, and this takes us to your website, right, Alex?
So yeah, and my co-founder is also on there, who started this, and I've
Mm,
been with him on it.
got it. And your law firm is called Decrypted Law.
Yep.
Cool. Well, it's a pleasure to have you on this live stream. Thank you so much for preparing the long list of questions that came in from the audience. And really, I really hope that this session can be of service to everyone who is watching either now or later. So thank you again, Alex, and
Yeah.
talk soon.
Yeah. Thank you very much, and hope you guys realize lawyers are friendly. We're here. We're here to help.
Yeah, now I know. Now I
Yeah,
know.
don't want suits. Suits is a lie. All right. Well, thank you, Nancy, and thank you everyone for coming.
Bye.
Bye.